Public Protector back on the line, Adv Kholeka Gcaleka. Adv Gcaleka, good evening. Perhaps you can hear me much clearer here. The question I started there with which you attempted to answer was whether or not the announcement that was made by the Premier earlier today absolving or dissolving rather the CPW, whether that's in line with the remedial actions recommended in your report.
Good evening once more. Yes, it is in line with that. The findings of the Public Protector are that the Wardens are actually established not in line with applicable legislation, and therefore that they had to be regulated. So upon interaction with the Gauteng Provincial Government, even from the inception of our investigations and even with the Section 79, which is our notice of intent to make adverse findings and our intended remedial action, we had actually submitted as such to the Premier and the rest of those who are involved at the Gauteng Provincial Government.
Yeah, let's talk about how the Premier had and the Gauteng Provincial Government arrived at the decision to establish and deploy the CPWs. You note in your report that both the Minister of Justice and the Minister of Police had rejected the Premier's request for this to be established under the Criminal Procedures Act, and that a technical committee was set up to advise the Premier on what possible ways could be followed for this to be done. They then decided to do it under the National Traffic Act. Talk to me about what level of responsibility the Premier must accept on his part for following the recommendation of the technical committee after the Minister of Justice had explicitly said no.
I think we must appreciate, Oliver, that from the evidence before us, there's actually no technical decision-making process that the Premier was actually involved in. It is the functionaries of the Department of Community Safety who were actually involved in this particular process and also advised up until decision-making stage on the legal provision within which the Wardens must be established, which we then find that was inconsistent with the law.
Yeah, and of course there were financial incurrences as a result of the deployment of the Wardens. It was perhaps outside the scope of your investigation and your considerations in this instance, but what is to be made of the consideration that money would have been spent under an illegal operation?
Of course, that is what we were concerned with, but it was not within the scope of our investigation. That when money is spent, we at least need to ensure that the considerations that are taken are in line with the law, hence the remedial action, which we had communicated even in June to the Gauteng Provincial Government, is that they have to ensure that this particular project of the crime prevention Wardens is properly regulated.
Who within the Gauteng Department of Community Safety carries culpability for the irregular implementation of this?
It is most obviously the legal team that advised on the legal provisions, and ultimately the accounting officer within community safety who was involved in the process. However, I want to emphasize that with the evidence before us, there is no evidence of them having been malicious. Hence, we did not take remedial action in terms of a disciplinary action to be taken, but rather that appropriate training and competency upliftment needs to be done to ensure that the legal division in particular is able to interpret the law correctly and advise in an appropriate manner.
But isn't that letting them off a little bit too light there, given that the test of malice doesn't seem to be a singular and an important, perhaps even an exclusive test in whether or not a public bearer has transgressed, whether negligently so or otherwise, in the exercise of public power when they disregard what is the standing law. It's not just about well-meaning people can do bad things too. Not being well-meaning doesn't absolve you of that. Surely some action must be taken against them.
You have to look at the facts in their totality. Firstly, the reasons why the crime prevention wardens were considered in the very first place is because of the high crime rate within Gauteng, which is undisputable, and therefore it was regarded as one of the priorities within the province, and therefore that there needed to be some plan that needed to be implemented to ensure that SABC and law enforcement generally within the province is being enhanced. The only issue was the regulation and where would they have been placed and how they would have been placed, and that is where the challenges became and the irregularities became. So when the public protector considers a matter, the public protector doesn't have to be punitive at all times. The public protector has to look at the intentions, and it has to look at the case in its totality.
Yeah. And just lastly, very quickly, the original complainant, Advocate Paul Hoffman, had made the argument that the Premier had tried to establish a policing function in the province when provincial governments don't have the power to do so. Does the totality of the outcome of your report agree and concur with that claim?
When you look at our report, firstly, we have to assess what has been done, what happened, what should have happened, and how do we remedy it. So here in what had happened, it is not the Premier who actually established the wardens. The Premier, yes, made a pronouncement on the interventions that the province would do in order to ensure that it assists in crime prevention. Now, the implementation of that announcement was then vested with the officials who had to do that. And yes, the manner in which they had embarked on it was irregular. Hence, we had issued a report with adverse findings.
Yeah. Did the Premier know that you were going to publish your report today, or was it just a sheer coincidence that he made the announcement a few hours before you published the report?
Well, it was a sheer coincidence. However, he knew that the report would be published post the Section 79, which was communicated to him and the Gauteng government in June this year.
We're going to have to leave it there. Thank you so much for your time this evening. Really do appreciate it. Public Protector of South Africa, Adv Kholeka Gcaleka, speaking to us there on the report issued against the Gauteng provincial government.